Start. Although it might seem a bit odd at the first blush that people of the same gender complain of sexual harassment against each other, it is not improbable, particularly in the context of the dynamic mood which the Indian society is adopting currently, even debating the issue as to whether same gender marriages may be legalized. Stop. The term sexual harassment as defined under the section 2 within bracket N of the POSH Act must be interpreted against the background of the social standpoint and cannot be regarded as a static concept, that the sexual harassment contemplated pertains to dignity and does not mean that a person of similar gender cannot hurt many modesty or dignity. Stop. The High Court also decided that same gender complaints under the POSH Act are maintainable. The Supreme Court in the case of Vishakha and others versus State of Rajasthan and others within bracket JT 1997 within bracket 7 SC 384 had laid down guidelines within bracket Vishakha guidelines bracket close for prohibition and prevention of sexual harassment of women at the workplace and dealing with cases of sexual harassment at the workplace, which was later superseded by the POSH Act. Stop. In the present matter, the complainant levied the allegations against the applicant of stalking and chasing her in front of other male and female colleagues at the workplace. Stop. A plea was filed by the applicant to quash the first information report within bracket FIR registered against him under sections 354 and 509 of the Indian Penal Code, 1860, and the complainant had filed a compromise affidavit in this regard. Stop. The Bombay High Court did not accept the compromise affidavit submitted and found it unconscionable to accept the compromise as it would be against the interest of justice. Stop. The High Court, after considering the merits of the case, stated that there exists no ground for quashing of the FIR and the consents of the FIR were spelled out by the complainants and the same allegations have been stated in the charge sheet and the petition was dismissed. Therefore, the High Court observed that the objective of Vishakha guidelines will be defeated if the complainant is compelled to withdraw the complaint. Stop. Gujarat Labour and the Employment Department had issued a notification under Section 5 of the Factories Act, 1948, exempting factories in the state of Gujarat from various provisions relating to weekly hours, daily hours, intervals for rest, etc. for adult workers under sections 51, 54, 55 and 56. Stop. The issue raised before the court in the present matter was whether the COVID-19 pandemic and the nationwide lockdown falls within the ambit of public emergency as defined in the Section 5 of the Factories Act stop. It was held that statutory provisions which affords dignity and rights to the workers cannot be done away with on account of a pandemic situation by the Gujarat government stop. In this regard, the pandemic does not qualify as public emergency within the purview of Section 5 of the Factories Act, 1948, threatening the security of the nation stop. It was noted that the notification violated the workers' right to life and right against forced labor guaranteed by Articles 21 and 23 of the Indian Constitution, and the court directed the payment of overtime wages to all eligible workers who have been working since the notification was rolled out stop. Thus, the notification issued by the Gujarat government was quashed stop.